Hello, everyone, and thank you for joining us for today's Spartans Step Up conversation featuring Susan Racey and Case Western Reserve University's own Strategic Giving team. The Office of Strategic Giving provides support and guidance for our friends and alums as they navigate charitable giving, and we like to be your one-stop shop of the who, what, when, where, why, and how of charitable giving and planning. To briefly introduce our panelists, my name is Amanda Pinney, and I am the Assistant Vice President of Strategic Giving. I am a proud alum of the Case Western Reserve University School of Law, an avid skier, and a former French student who still likes to pretend I can speak still. Next up, we have Kristan Rothman. Kristan is our Associate Director. She is a former theater major with a master's degree in nonprofit management, and Kristan spends what little free time she has running her children from ice skating practice to wrestling practice. And to my left here is Ellen Halfron. Ellen is our Senior Philanthropic Advisor. As a private wealth attorney and estate attorney in Cleveland for more than 30 years, Ellen worked with individuals a lot like yourselves on their estate plans. Like Kristan, Ellen also started in the arts, and when she's not working, she spends quite a bit of time and energy enjoying the company of her dog, Maisie, with endless walks and ball throwing. And our featured guest, Susan Racey, is a partner at Tucker Ellis. Susan was an undergraduate at the University of Dayton and also earned her JD from Case Western Reserve University School of Law. Susan focuses her practice on estate planning and business succession planning, probate trust administration, charitable giving, and taxation. She is also an Ohio State Bar Association specialist in estate planning, trust, and probate law. An avid horsewoman and specialist in equine law, Susan's clients describe her as a fierce advocate, very thorough, very careful, and nice to work with. So thank you. Okay, now let's get started. We're going to begin today's conversation around the who, what, where, when, and how of non-cash gifts. As a couple housekeeping items, our goal is to share some ideas on how to use certain charitable giving vehicles to help you fulfill your goals. Some of you submitted questions, and we're so grateful that you did that, and we're going to save those for the last 15 minutes of the segment. If we're not able to respond to all the questions, we'll follow up with everyone individually and make sure that everybody has the information that we share here today. Also, please feel free to enter questions in the chat on your screen, because we're also going to be monitoring the chat, and we'll follow up with those responses as well. I will now turn it over to Kristan Rothman to share with you our first vehicle. Take it away, Kristan.
Thank you so much, Amanda. Today we plan to cover 3 very effective planned giving vehicles. Those are going to be will and trust bequests, beneficiary designations, and the charitable remainder trust. We're going to provide an overview for how you can use these assets to make a gift during your lifetime or through your estate. And so for each of those topics, we're going to cover the what is the vehicle, when and why you might consider using the vehicle to fund your gift, the how, the steps or processes you might take to make a gift with that vehicle, and then who can help you with the decision and process for using that vehicle. Finally, we're going to provide an example of how that asset can or maybe has already been used to make a meaningful gift at CWRU. We know there are a lot of other options for you to consider, including gifts of property, gifts from donor-advised funds, gifts of life insurance, and a multitude of trusts. While we're not going to be able to cover all of those options and opportunities in this session, we hope you'll join us for a future Spartans Step Up session where we hope to cover some of those things. And please reach out to our strategic giving team if you have any questions that come up today that we haven't been able to answer, or if any other ideas strike you, we'd be happy to explore those and then run illustrations or talk through scenarios with you. Finally, we'd love to hear your feedback on today's session and also any suggestions for topics you might have for a future session. So please make sure that you complete that survey that comes out after this session today. You'll see that in your email. And I'll turn it right back over to Amanda now to get us started with our conversation.
Fantastic. Thank you, Kristan. We hope everybody gets a kick out of our slides today and maybe a little bit hungry. We are filming this during the month of November, so Thanksgiving for those of you who watch this in hindsight. So we stuck with a food theme today, inspired by Susan and some have your cake and eat it too, which we'll see in a little bit. But we're going to start off with the, quote, meat and potatoes of charitable giving vehicles, and we're going to talk about gifts from a will or trust. Right out of the gate, what is a will or trust bequest? This is a charitable gift from your estate. Period. End of story. Very, very simple. No other planned gift is as easy to make, easy to change, and should you ever need those assets during your lifetime. But Ellen, why don't you and Susan take a deeper dive into the applications of this vehicle, including the benefits?
Okay, thanks, Amanda. And as you'll see on this slide, when might a bequest be the right gift for you? If you want to make a gift to the university, if you want to leave a specific amount, you want the flexibility to change your mind, you want continued access to your wealth should you need it. So I'm going to ask my first question to Susan. And when working with your clients, Susan, do you find that what are some of the recurring issues and themes that you might find that you would discuss with them about charitable giving in their estates?
So this type of gift through a will or a trust where you designate in your estate plan that a gift will be made after you die, it is very, very simple. And one of the reasons that it is a simple and attractive gift to my clients is one of the concerns that they have that will there be enough assets to adequately provide for themselves is not an issue here because this gift happens at the time of death. One of the reoccurring things, though, is will there be enough for their family? So a residuary gift is often used for those type of clients. And the reason that's attractive is because the gift that goes to the charity is after debts, expenses, taxes, and the provisions that they want to provide for their family are paid, and then the charity gets what's remaining.
And just to reemphasize that wills and trusts, wills are always revocable, but a trust can be irrevocable, but you have to specifically make it so. So these documents can always be changed. And on this slide, it's a little small for you all to see, but this is a form that we use sometimes for our donors, a letter of intent, which is a non-binding expression of their intent to make an estate gift. And what this helps us, it helps us by knowing what the donor's intent is, and also, not just the amount, but where they might want their gift to be used by the university and for what purpose. Amanda, can you share with us a scenario for our guests that might be helpful in this regard?
I can absolutely do that, Ellen.
That's so good. Thank you.
As Kristan said too, we try to put some scenarios in all of these presentations so you can see kind of a real life application of how this would work. We're going to talk about Natalia. Natalia, a widow, has been a university supporter for many years. She is in good health now, but does not want to be a financial burden to her children should she require expensive health care in the future. The university is one of two charities that which she has been most dedicated. She would like to make a lasting gift to each of them in memory of her husband. After discussing options with her estate planning advisor, she decides to create a residuary bequest in her will for each of her two favorite charities. Each charity will receive 50% of the remainder of her estate after, as Susan said, all other obligations, such as taxes, bequests to her children and grandchildren, have all been taken care of. But now I'm going to turn it back over again to Ellen and Susan to discuss some of the benefits for Natalia's plan.
Okay, and I'm going to let Susan start with that. Why don't you go ahead, Susan?
So as shown on the slide illustrating Natalia's gift, the benefits to Natalia first are the fact that these assets are available for her use until she passes away. Second is it's completely revocable. until she passes away. So she can change as to who the charities are, what she, in this situation, it's a residual gift, but she could even change and decide to make it a specific gift to the charity, but it's completely revocable. And also, depending on the size of Natalia's estate, by making these charitable gifts at her death, her estate may receive tax benefits through a charitable deduction.
Thank you, Susan. So what we have here is an opportunity for Natalia to plan for a generous legacy to the university or to other charities. In this case, 50% to two charities that she is committed to. And it also, by documenting this, we'll stress this a couple of times during the presentation, rather than waiting until someone dies to find out about the gift, there's a tremendous benefit in sharing that with the university in advance. That helps to ensure that the gift is going to be aligned with what the university can do and what it needs. And it also can provide great satisfaction for the donor, for Natalia, because she's going to get that recognition and have the confidence to know that the gift will honor her and her husband the way she wants. Susan, I had another question for you. Do you find that it's beneficial for your clients to work with the charity in advance?
Yes, absolutely. Not only is it beneficial for the charity, as Ellen, you mentioned, because then you might have an idea what's coming and what it could be used for, but for the client or the donor to know that what their wishes are can be fulfilled because they've worked with the charity and the charity has said, yes, we could use the gift for that, or that is possible to have happen. I find it gives the donor great peace of mind that it will, and the relationship in the process of working through how the gift will be used makes them even more comfortable.
Right, right. Thank you so much, Susan. So I'm going to turn this over to Kristan now to talk about our next topic, which is using beneficiary designations to fulfill your charitable giving.
Excellent. Thanks so much, Ellen and Susan. I hope that gave the audience a good overview of the will and trust bequest vehicle. Next, I'm going to walk you through our second vehicle, sort of the bread and butter, if you will, of charitable giving options, the beneficiary designation. So beneficiary designations are one of the simplest ways you can make a gift to a charitable institution like CWRU. Often, it's as easy as filling out a simple one-page form. Operationally, donors would request the appropriate designation form from their brokerage, IRA administrator, or whatever other institution is administering the asset. The donors can designate all or a percentage of the assets to each beneficiary they'd like to support. And it's really especially important, as Susan pointed out, to make sure that your gift is thoroughly documented with the receiving beneficiary. Most designation forms are only going to have a very small space for you to indicate what the gift's use might be or what the purpose might be. And so documenting that through either a letter of intent or a gift agreement form is the best way to ensure that your wishes are carried out. Some examples of assets that can pass through beneficiary designation include retirement account assets. This would be IRAs, 401ks, 403bs. And passing these assets, of course, is a very easy way to pass things across to a charity through that beneficiary designation form process, but it can also be a very tax-savvy way to make a charitable estate gift, since these assets will be subject to income tax if they're left to individuals, while charitable institutions receive the assets tax-free. Susan and Ellen are going to dive a little deeper into the tax benefits of passing these types of assets to a charity in just a moment. But just to cover a few more examples of other assets that can be passed through beneficiary designations, life insurance is a very popular asset. This can be easily passed through the beneficiary designation process, but donors may also want to consider transferring ownership of the policy during their lifetime to the university for a current income tax deduction. investment accounts and bank accounts, again, through a simple form, but it's often known as a transfer on death or payment on death form. And these assets, of course, can be passed directly to charity that way. And then finally, a commercial annuity contract. While we don't see these as frequently here at the university, they pass very similarly to a life insurance policy, again, through a simple beneficiary designation form. I'm going to turn it back over to Ellen and Susan, who have some practical advice to share regarding beneficiary designations. Is that right?
Yes, thanks so much, Kristan. Susan, Kristan's done a great job of showing how simply this can be done and how beneficial it can be for donors. Do you find that this is something that your clients are aware of? And if not, how do you bring that up to them in conversations? What points do you think are important for your clients to know?
Actually, often clients do not think of using a beneficiary designation. They, in their mind, sort of are thinking of a charitable gift through the classic sort of in my will or in my trust. And as we all know, if it's left in the will, it has to go through the entire probate process before it can pass to the charity, and it also becomes public record, and everybody knows about it. So usually it's the professional advisors who are raising this with the clients. And often it is the best vehicle for a donor or one of our clients to make a charitable gift because it's simple, it's immediate, it's a non-probate asset. It passes immediately to the charity, and it's private. The only one who knows about the fact that that asset has been transferred to the charity is the charity. And it can be an excellent vehicle. Also, with respect to retirement accounts. And Kristan, thank you. You teed it up beautifully in raising the fact that if retirement assets are left to the family, they are going to be subject to income taxes at ordinary income tax rates. Those exact same assets can be left to the charity, and the charity is going to get it 100 cents on the dollar, income tax free. So we find that it has become an even more beneficial asset to use to transfer to the charity since the recent change in the tax laws a couple years ago, what is known as the Secure Act. Whereas before, if you left it to the family could at least, the child, in this example, could stretch out taking the payments out of the retirement account over their life expectancy, which could be decades. Now with the change in the law, it has to be taken out within 10 years. So, and they get hit with all that income taxes within 10 years. So that has made it an even more attractive vehicle to leave for charities.
That's really helpful. And then I would add, Kristan touched on this, and just like with the other, if with a will bequest or a trust bequest, sharing your wishes for this kind of a beneficiary designation with the charity or here with the university can be really, really helpful because, as Kristan pointed out, in the beneficiary designation, there often isn't going to be space or not even allowed for you to state a purpose. So that's going to come to the university undesignated. So working with the university in advance to create either a gift agreement or a letter of intent where the purpose for that gift is documented in some way so we know how you want to use it, that's really important. So we are now going to move on to one of my favorite topics, which is charitable remainder trusts. This is what we call our have your cake and eat it too topic. And I'm going to give you just a brief overview on charitable remainder trusts. What a charitable remainder trust is an irrevocable trust that generates an income stream for the donor or for another beneficiary, either for a term of years or for their lifetime. The term of years is capped at 20 years if it's done as a term of years instrument. And then at the end of that term, the remainder goes to charity. There are several different options for doing these. As shown in the slide, it can be an immediate income stream, meaning that the income beneficiary starts receiving the payments right away. Sometimes it can be delayed. It can come at a specified date in the future. There also are two main types of charitable remainder trusts. One is an annuity trust, which pays a fixed payment for the entire time of the term. The other, which is much more common because it is actually more beneficial and flexible for both the beneficiary and the charity, is a unitrust. And what that means is that the payments each year are based on the value of the trust every year. So if it's a 5% payment, it's going to be 5% of the value of that trust valued each year. Hopefully that is a number that's going to go up, and that ratably both the income beneficiary and the charity will benefit from that appreciation over time. So who would a charitable remainder trust, when might it be a good thing for you to consider? If you want to make a charitable gift, but you still want to retain an income stream, either for yourself or others. You want the possibility of income growth. As I said, with a unit trust, you can still get that growth. A charitable remainder trust is actually a tax-exempt vehicle. So, for instance, a gift of appreciated securities to a charitable remainder trust, it can be sold by the trust with no capital gains and then diversified to produce that income. You may want to choose the person who administers the gift and guides the investments. There can be flexibility as to who can be the trustee, including the donor themselves. And of course, if you want to make a generous gift to Case Western Reserve University, we do serve as trustee of charitable remainder trusts. Our policies require that it be a gift of $100,000 or more, and we actually only, if it's a lifetime trust, we will only do them for individuals over 65. So I'm going to, Susan and I are going to have a little bit of a dialogue about our experience with charitable remainder trusts. And I did a lot of these when I was practicing law, and then I've done them for the university here. So who do you find, Susan, are the prime candidates with your clients for doing charitable remainder trusts?
Since, these are just wonderful vehicles, I love charitable remainder trusts because you can make them really do so much and benefit your clients in different ways based on their particular circumstances. But if it's going to be a lifetime trust, so it's going to really be there for their entire lifetime, with the charity getting it after they have passed, and often it's a donor and possibly a donor and the donor's spouse, then usually they're 65 years of age or more. However, if it's going to be a term of years, charitable remainder trust, and as Ellen had said, it cannot extend beyond 20 years, but it can be 5, 10, 15, whatever makes sense, or what the donor wants to do. Because often they want, for example, an income stream until maybe they get to retirement age, when Social Security is going to kick in. But then they also want it to end and have the charity be able to receive it while they're still living and enjoy all the benefits that come with giving a lifetime gift that way. So really any age of a donor works with a term of years trusts. So also we find that anyone who has like low basis appreciated assets, usually marketable securities, where if they just sold it, they're going to pay capital gains on it and then only have the amount after the capital gains has been paid to reinvest and get income off, can put it into a charitable remainder trust. All of it can be sold, diversified, better investments, purchased for their current needs on 100 cents on the dollar, because it won't pay any tax, and they can start to draw the income, whatever percentage they chose, 5%, 6%, etc. Also, if a donor needs a current year income tax deduction, so they've sold assets, they just had, income that they've realized this year where they say, I could really use a charitable deduction. The beauty of a charitable remainder trust is when you fund it and you're going to get the income stream from it, and the charity's not even going to get any part of that for a while, whether the end of the term of years or the lifetime, you get a current year, the year you fund it, charitable income tax deduction. Now, it's not for the whole amount that's put in there. It's for what we call the present value of the remainder interest, which has to be at least 10% when we run the calculations. So for example, if someone put $200,000 into a charitable remainder trust and did it for a term of years, and when we did the calculation, the remainder interest was 30%, so $60,000. They would be entitled to take a charitable deduction that year of the $60,000.
Right.
So you may want to add to that. I mean, you're a rock star estate planning attorney, so
Making me blush.
Yeah.
But
You've done a lot of these.
I have done a lot of these, and I have to say that donors, my clients when I was practicing, they're really happy with them. Right. And just for our audience, just so that you know, we can run these calculations. We can run illustrations for you that are really user-friendly, that will show you exactly what your payments will be, what that charitable deduction might be. We can even plug in investment projections that would show, for instance, with a unit trust, how we think your payments over time will grow. And it's really rewarding also to see, wow, how much is the university going to get at the end of the term? So I'm going to turn this over to Amanda now to share a scenario of, and these are based on real experiences that we have with our donors.
Okay, we're going to do charitable remainder trust scenario with Susan and John. Susan is 76 years old and her husband John is 75. Many of the stocks in their portfolio have appreciated substantially in value over the many years the couple has owned them. They're enthusiastic about making a major gift to support Case Western Reserve University, but they also would welcome a way to receive greater income from their investments without paying, as Susan and Ellen just talked about, a big capital gains tax. After consulting with their advisors, Susan and John find that a 5% charitable remainder unit trust funded with $500,000 in assets will meet their needs perfectly. They fund their unit trust with a combination of appreciated stocks with a low basis and low dividends and cash. And Ellen and Susan, I think this scenario also brings up another great question for our audience. What are some other advantageous options for using charitable remainder trusts for planned gifts?
So thank you, Amanda. One of the points I wanted to make is that we've kind of hinted at this, that a charitable remainder trust can be funded during lifetime to provide immediate benefit. It can also be funded as part of one's estate plan. We sometimes have donors, and I remember having clients as well, who would say, I want to leave an asset or I want to leave a gift to charity, but I'd maybe like my children to have the income from that asset for a period of time. So they might set up in a testamentary as part of their estate plan for a term of years trust for a child for 10 years. So one of the advantages with charitable remainder trusts is they can be incredibly flexible, both in terms of the terms of the charitable remainder trust, who it's for, and how you set it up. And Susan, could you maybe share some ways that a testamentary charitable remainder trust might be helpful for a donor?
Absolutely. And thank you, Ellen. And it's for the reason sort of you have hinted at. So first, our clients often worry about, that they're going to have enough assets for themselves and their spouse, and that they have enough income flow. And these charitable remainder trusts can just provide so many wonderful benefits, from giving them a income stream that they can count on, to also giving them, tax deductions. Or also what's in the charitable remainder trust at the time of their death, if it's for example, the donor or the donor's spouse, will then be out of their taxable estates. But then there's also another group of clients who are concerned about that next generation after them. Will they have enough? Or they have a child who they just want to make sure is going to get an annual income stream so that they just have peace of mind that they're going to be taken care of. So you can create what's called a testamentary charitable remainder trust, and that just means it's created at the time that the donor dies. And a couple things with that is the benefits are sort of what I just described, this consistent income stream for the beneficiary, with ultimately the charity that they're fond of after either a term of years for that beneficiary, in this example a child, or after the child's death. those assets will go to the charity. In addition, because they're very flexible vehicles, that if at that time, because we don't have a crystal ball, so we don't know what the child's needs might be, but at that time, if the child thinks he doesn't need, that money, can always disclaim the gift and it can go immediately to charity. Can at any time, sort of during the administration of that, decide they're going to gift part or all of the balance of the income interest to the charity, and then the charity will get assets prior to the scheduled end of the term for the charitable remainder trust. One of the other benefits here, and this is going back sort of to that, what we mentioned a little earlier, the changes in the laws with respect to retirement assets with the Secure Act, is one of the planning vehicles that have become popular is the use of a charitable remainder trust to give a beneficiary the ability to get payments stretched out over lifetime, as opposed to having to take it out of the retirement account over the 10 years. And this is how that works. And I'm just going to, if anyone wants to, ask a question, we can follow up later on it, but I'm going to simplify this very much, is because the charitable remainder trust is like a charity, is tax exempt. It can take in those payments over the 10 years or immediately as a lump sum and not pay the income taxes on it. And then through the amount, the percentage that the beneficiary will get, they will receive that over their lifetime. So it doesn't get that immediate income tax hit. And so that's what we're finding another way, where that have made testamentary trusts even more popular than they were before that time.
So that's so helpful, Susan. Yeah, the flexibility of these instruments, you can get very creative with them, and they work out so well for the family and for the individuals. A couple of other points that I'd like to make is that if a donor wants to retain investment control of the assets in the charitable remainder trust, they can do so either by serving as trustee themselves, or sometimes having their investment advisor or another individual service trustee. But as I mentioned earlier, Case Western Reserve University does serve as trustee of a number of these trusts. We do have a minimum, as I said, of $100,000, and also we need to be the beneficiary of at least 50%, but it is possible you can name another charity for the other 50%. The other beauty of a charitable remainder trust, besides all the other benefits that we've talked about, is that the charitable remainder trust the agreement itself serves as a gift agreement, where we can very specifically state the terms of how what remains for the university will be used when the front term ends, either the term of years or the lifetime. The document will set that forth. So we'll be able to know what the donor's intent is and be sure to carry it out. How are we doing on time? Do we know?
I think we're spot on.
Oh, good. Okay. I think we're probably done with charitable remainder trusts. We do, as we said, we can run scenarios for these. We can run illustrations. We can work with your advisors. And we do that actually even on our website. There's even a program, if you delve into our planned giving section of our website, you can even run the numbers yourself. But we're happy to help. Susan, moving on, do you have some final observations regarding charitable planning and trends that you're seeing with your clients?
I did want to mention two trends, because they may be planned giving vehicles that, or sort of approaches that our audience has not heard of yet. So, and they're both either sort of new because of a change in the tax laws, or just have become even more popular because of the change in the tax laws. And the both are really affected by the changes that occurred a few years ago, where the standard deduction was raised. So many more folks do not itemize. And when you don't itemize, generally you lose your charitable deductions because those are itemized deductions. So one of the approaches that has become popular is what we affectionately call bunching. And with also having donor advised funds, it has made it very easy and attractive to do. So what bunching is making a large charitable gift in 1 year, in sort of offsetting years. And we sometimes see 2-year bunching, 3-year bunching, 5-year bunching. So how it would work, and let's say someone was doing a 3-year bunching, they would make a large gift in year 1, take the charitable deduction, not use their standard deduction, actually itemize that year so that they can use that charitable deduction. And then in the 2nd and 3rd year, not make a charitable gift and use the standard deduction. Now, initially when you're hearing that, you're probably saying to yourself, but I want to do what I always do. I want to gift to my charity annually. I don't want to gift 1 year and then forego 3 years. They count on my gifting, and I want to make sure I spread it out. And with a donor advised fund, what happens with the donor advised fund, as you may know, is you can put monies in a given year and not have to spend them all. So you can put the large gift into your donor advised fund, but then request that it be doled out to the charities sort of in the exact same way that you historically do it. Mm-hmm. So that has become very, very popular. The second one is with respect to what you may hear as QCDs, which are the qualified charitable distributions with your retirement accounts. In several years now, and they've, it's always sort of been, at risk of going away, but I think it's so popular that we still have it, and it's wonderfully beneficial both to donors and to charities, is the ability to take up to $100,000 of your required minimum distributions and have it paid directly from your retirement account to the charity. And now why has that become even more popular? And that is with the same change in law that I talked about with the standard deductions. It's not an itemized deduction. So this can be over and above you can still use the standard deduction and make this qualified charitable distribution to the charity, and it's completely out of your taxable income for that year.
Right. Yeah, I've discussed that in other presentations because for individuals who are not itemizing, mm-hmm. if you're making, let's say you're making a charitable contribution of $5,000 and you're not itemizing, so you're not getting any tax benefit out of that if you're using after-tax dollars. But if you do it from your retirement fund mm-hmm. as a qualified charitable distribution, you're not going to get taxed on that. So you're not getting a charitable deduction, but you are avoiding the tax. And that just for anyone who's not familiar with that, you do have to be over 70 and a half Correct. To be able to do that. Right. I guess as we sum up, a couple of other advantages for charitable giving and working with our university. We do really encourage you, as we've said several times during this presentation, to talk to us about your giving goals. It's a win-win. It helps ensure that your gifts are going to be used the way you want to. It also helps us to plan and be sure that we can carry out what your wishes are. And our goal is to help you identify your passions. And we in the Office of Strategic Giving can do that. We can direct you to individuals at the various schools who can work with you. And by also working with us in advance with the illustrations and helping with the planning, we can actually maybe save you a little bit of legal fees. We don't give tax advice, but right. by helping Absolutely. With the planning in advance, we can give you ideas that you can then go back to your practitioner. And we do that quite a bit. So I think that sort of brings us to the end. Do we have time for our questions?
We do, Ellen, and I think it'd be great. We're actually spot on. I hope our viewers are having fun and, you know, having their cake and eating it too, bread and butter. But there were some really, really thoughtful questions that were submitted by several of the audience members, and we're going to check the chat here too. Kristan, can you get it started with the questions?
Absolutely, yes. And you know, as we promised, we're going to cover some of those questions. Thank you so much, everyone, for submitting those, and we'll be watching that chat to make sure that we bring in some of those questions from the live chat. If we run out of time today, don't worry, we'll be sure to follow up directly with you on any unanswered questions. So Susan, this first question I'm going to direct to you.
Okay.
This comes right from our registration. When is it better just to put in a trust or will that residual monies of an estate be given to CWRU without first tying up the money in a financial vehicle, in case one's circumstances might necessitate one needing more of that money while still alive than just the interest it generates?
Excellent question, and we discussed it a little bit earlier, so I hope we answered the question in that, but just to sort of go back to that. If someone is concerned that they may, you know, not have enough money to live on, making the gift not only in a will or a trust, but even possibly, as we discussed, through the beneficiary designations, is maybe the route they want to go. And the reason for that is all of those are completely amendable, changeable up until the time of death. And obviously then the donor will have access to those monies up until the time of death. And I don't know if Ellen or if anyone else wanted to add to the answer to that question.
Yeah, I think that answers it well.
Excellent. Thanks so much, Susan. Ellen, I have another one for you. How do I modify an existing revocable trust?
That also is a good question. And as Susan said, and I think I mentioned earlier, that revocable trusts are, just like the name says, revocable. There are irrevocable trusts that we use for certain kinds of planning, but trusts that are generally set up as, in a sense, a will substitute, where all of your provisions for giving to family and paying taxes and to charity are all in the trust, maybe rather than in the will. Those are entirely revocable and amendable. So amending your trust is as simple as, it's really something that you should contact your attorney, whoever helped you draft the initial revocable trust. So as long as the person who created the trust is still competent, if you're not talking about yourself and somebody else, as long as they are still able to make those decisions and sign those documents, it can be as simple as a 1 or 2 page amendment, which is just changing whatever provision you want to amend. If there are more changes that you want to make, oftentimes it would be done as a full restatement so it's basically redoing the whole document and restating it and sort of starting from scratch.
Right. Thanks, Ellen. Now back to Susan. I'm going to give you this one. Is it better to set up a trust for high value assets like a home or securities, or to simply identify such assets in the will and an addendum?
So I know this it doesn't have to do with like charitable planning, but I am a huge fan of trusts. In fact, if I was ever going to go on the show Survivor, and you know how you're allowed to take one item with you, I would take a trust because I can literally get this trust to do anything. So, but some of the reasons for that, as opposed to the will, is that if you create a trust and you fund the trust with these assets, at the time of your death, they're going to avoid probate first and foremost. Probate can be a lengthy, expensive process, and also any assets that have to go through probate, it all becomes public record. Trusts are private. It's seamless in their transfer to the beneficiaries, you know, with a trust. Also with a trust, if you became incapacitated and the assets are there, it can preclude a need for a guardianship. Your successor trustee takes over and it can be administered without having to bring in the court. Also, trusts are really nice because they are sort of a basket or a pot. You can have all kinds of assets flow into the trust. and then divide from there. Pay expenses and then divide from there, as opposed to having things sort of be piecemeal, particularly with the family. You know, a little different with the charity, because sometimes using the beneficiary designations, because it's simple, quick, immediate, and private, works, but sort of when you're talking about for like the family to be able to get everything in, and you don't have a crystal ball, so we don't know who's actually going to be living at that time. You know, a child might tragically predecease you, and you've got grandchildren. It can all handle that in the trust. So I hope I answered that with a
Excellent. And I think we have time for one final question here, and this is one that we get pretty frequently. So I'm going to throw this to Amanda. Amanda, what happens, as Ellen mentioned this earlier, what happens when an undesignated estate gift comes into the university?
Excellent question. I wish I had a survivor analogy to go with it, so I do have to think about that. But I have to say, number one, we're always so just, it's an amazing thing when someone has left a gift to the university. And when someone has taken the time to do that, I think it's really important for the institution to do our homework, do our due diligence, and do our research, and make sure that we're putting those assets where the donor wants them to go. And I'll give a plug to President Kaler too. He is so thoughtful in what happens with an undesignated bequest. So we get these in all the time where someone says we leave X dollars to the institution. So what President Kaler has us do is a full research profile on the donor. What did they care about? What school did they go to? Are they an engineer? Are they a nurse? Are they a graduate of the social work school? So we can kind of paint a picture of what that person was, what they cared about, and what we can do that would be a nice legacy in their honor. So it's very thoughtful, but we always check the source document and make sure that if it says we have to set up an endowment, or if it's for scholarships but doesn't say a particular area, we make sure we comply with that document, but we also make sure that we can take that donor's intent and do something very meaningful with it.
All right. I think that is probably going to cover it for all the time that we have today. I do see that we had some more questions come in from the chat, so we will certainly be following up with people directly to answer those questions for you. Thank you all so much for joining us. We'd like to thank Susan for joining us to share her time and expertise today. If you have any additional questions about today's session or any other estate gift questions that come up, please feel free to always contact us, always reach out to us. We did have a slide up there with our contact information. You can reach out to the Office of Strategic Giving, Amanda, Ellen, or myself, or Susan at Tucker Ellis. And we look forward to seeing you at a future Spartans Step Up. So thank you so much, everyone. Thank you.
Thank you.
Thank you.